morning. Today is Tuesday, February the 9th, 2016. It's 10 a.m. It is my pleasure to call to order the Tennessee Department of Commerce and Insurance Board of Funeral Directors and Embalmers. Ms. Lisa Mosby, will you please call the roll?
Dennis Bridges. Here. Mark Carthen.
Here.
Robert Davis.
Here.
Jeff Duffer.
Here.
Robert Helms.
Here.
David Neal.
Here.
Charles Ram.
Here.
Mr. President, we have all board members present.
Thank you, Ms. Mosby. Now at this time, we have 4 new board members that we would like to recognize. Charles Ram, Jeff Duffer, Robert Davis, and Dennis Bridges. We would like to congratulate each of these members to the new appointment and look forward to working with each of these members in the coming year. On to the agenda. Take your time and look at the agenda for a minute.
Make a motion to adopt. Second.
I have a motion by Mr. Ham, second by Mr. Cochran. All in favor say aye.
Aye.
Motion carries. On to the adoption of Robert Rules of Order. The rules contained in the current edition of Robert Rules of Order newly revised shall govern the board in all cases to which they are applicable and which they are not inconsistent with statutes and any special rules of order the board may adopt.
I'll make a motion to accept.
I'll second.
Motion by Mr. Cochran, second by Mr.
Rom.
Rom. All in favor say aye.
Aye.
Motion carries. Conflict of interest statements. Each board member must sign the conflict of interest statement.
All conflict of interest statements have been signed by all board members.
Thank you, Ms. Mosby. On to the minutes. Take your time and look at the minutes for November and get approval for the November minutes.
Motion to accept the minutes as presented.
Second.
A motion, Mr. Helms, second, Mr. Cochran. All in favor say aye.
Aye.
Motion carries. December minutes. Go over the December minutes and look at those.
Make a motion to accept.
Second.
Motion by Mr. Cochran, second by Mr. Helms. All in favor say aye. Aye. Motion carries. Now to the legal report with Ms. Ellery Richardson.
The first 4 cases, and the first 2, it's the same situation, but 2 different funeral homes were involved and different people filed complaints. I thought it was more clear to do each funeral home separately based on the facts that were relevant to them. So that's how I've separated them out, but the facts will sound similar because it is the same situation, just so you know that going in. The first case is case number 2015-021-2081 against an establishment, and 2015-0212-082 against the funeral director. The deceased was at complainant funeral home. The ex-wife and children wanted cremation. Respondent states that he was contacted by the deceased's siblings who were opposed to cremation, and they wanted to transfer the body to respondent to straighten everything out. Respondent then contacted complainant's funeral director, who stated that they were not releasing the body. When respondent met with the siblings, the family told him that the other establishment had already scheduled the cremation and service for the next morning and asked him to help. The siblings gave respondent the deceased's will that specifically indicated that the deceased's sisters be involved and stated that he did not want to be cremated. Respondent then attempted to contact the complainant's funeral director again, but they were not cooperative. Respondent called the board office, which gave respondent the applicable statute for who holds the rights of disposition, and the statute that states it is prohibited to hold a body against the wishes of the ones lawfully entitled to the body. The family suggested that he call the police to obtain the body, so he did. After the police arrived at the other establishment, the body was not released, but the family agreed to cooperate and to not cremate. Respondent states that he encouraged the family to stay with complainant and work with the rest of the family. An investigation revealed that although respondent was acting at the behest of the deceased sisters, the children were the ones with the right of disposition. The sisters had a holographic will that was never probated by a judge, but it does not appear from my review to be valid. Of course, respondent would not have known that the will was not valid at this time. Complainant filed the complaint because it felt that calling the police on another funeral home is not the professional way to handle a family disagreement. So my recommendation would be to close, because the only potential violation would be this unprofessional conduct. Complicated situation.
Make a motion to accept council's recommendation.
I'll second.
A motion by Mr. Hams, a second by Mr. Cochran. All in favor say aye.
Aye.
Any opposed? Motion carries.
Next case is related. Case number 2015-021-8561 against the establishment that was holding the body during this time, and 2015-021-8562 against the funeral director. The complainant is the sister of the deceased. The deceased's children wanted to cremate, but the siblings did not. The siblings presented a holographic will during the arrangement conference that stated the deceased did not want cremation. The validity of this will is debatable. The siblings left after an argument. 4 of the 5 children signed the cremation authorization form at the arrangement conference. Even though the authorization was signed, the funeral home did not plan any cremation and told the children that they were holding off. The funeral home states that they then called complainant and her siblings and explained that they were holding the cremation and she could go before a judge with a will to probate it if she wished. At that point, the complainant asked if they could do a burial if the siblings paid for it. The children eventually agreed. The siblings were able to come up with $4,000 for the funeral and cemetery charges, and respondent gave them a $2,000 discount. Complainant states that respondent ignored the will and was rude, disrespectful, and ignored the siblings' wishes during the whole process, and that respondent never embalmed the deceased. An investigation revealed that the daughter declined embalming at the initial removal, and the deceased was refrigerated. The investigation did not reveal evidence of a violation of the funeral laws and rules by these respondents. It appears that the funeral home attempted to follow the right of disposition statute during a time of family conflict. So my recommendation would be to close.
Make a motion to recommend or accept the recommendations of the attorney.
Second.
A motion by Mr. Rahm, a second by Mr. Cochran and Hams. All in favor say aye.
Aye.
Any opposed? Motion carries.
Number 5 is case number 2015-021-9051. Respondent's establishment license expired on June 30th and was not renewed until July 21st. Respondent handled 14 cases during this time. Respondent apologizes for the oversight and states that he did not receive the renewal. So my recommendation would be a consent order with a civil penalty of $850 and authorization for a hearing.
17 cases.
17? 17. Is 14 written somewhere? Oh, sorry. 17.
And for the new board members, you guys have a standard.
What the board has generally done in the past is, in cases like this, the civil penalty is based on the amount of cases they did unlicensed. So it's generally about $50 per case, but that changes based on how many, because if they did, like 70, then there's some different things going on there.
Motion to accept council's recommendation.
Second.
A motion by Mr. Helms, a second by Mr. Rom. All in favor say aye.
Aye.
Any opposed? Motion carries.
Next case is case number 2015-022-0911. One of respondent's employees had an apprentice license that expired on April 30th, 2015. On August 26th, the respondent had its inspection, and the inspector noted that the employee was still listed as licensed on its website. Additionally, the website lists 6 individuals who are not licensed. Respondent states that they thought they made the correction when the inspector was on site, but since their website is supported by an outside company, the change did not appear. When the inspector informed them that the website still wasn't corrected, they contacted the company and paid to have it changed. I have confirmed the website is now corrected. Based on what the board has done in the past, my recommendation would be a consent order with a civil penalty of $250 and authorization for a hearing. And then the statutory violation is listed.
Motion to accept.
Motion by Mr. Helms, a second by Mr. Duffer. All in favor say aye.
Aye.
Any opposed? Motion carries.
Next case is case number 2015-022-4931 and 2015-022-4932. Complainant is the medical examiner. She states that she signed the death certificate after an autopsy on October 19th, 2015. In late November, they received the completed death certificate, but it is clear that it is not the same certificate she signed due to type versus handwriting in filling out of the form. Additionally, respondent forged her signature on this second death certificate. Respondent admits to forging the medical examiner's signature and stated that it was because of a clerical error in filling out the death certificate. Because the family was pushing to get the death certificate, respondent states that they just created another one and completed the medical examiner's section, including the cause of death and the forgery of the signature. So my recommendation would be for the establishment of consent order with a civil penalty of $1,000 and authorization for a hearing and for a letter of warning for the manager.
Motion to accept.
Second.
Motion by Mr. Helms, a second by Mr. Rom. All in favor say aye.
Aye.
Any opposed? Motion carries.
Next case is case number 2015-022-1861. Complainant is a funeral establishment that did embalming services for respondent. Complainant states that on the last 4 cases, respondent refused to pay. Complainant sent invoices, called multiple times, and finally had their lawyer send respondent a demand letter, but to no avail. The total amount owed is $1,775. Respondent states that at the time the invoices were due, he had some financial concerns based on another matter, so he withheld payment on some of his debts until that matter was concluded. He states that he will pay respondent what is owed within 15 to 30 days. That was over a month ago, and we checked with the complainant, and the invoices have still not been paid. So my recommendation would be a consent order with a civil penalty of $500 and proof of payment within 30 days. And then if the order would also say that if payment is not made within 30 days, the civil penalty would then increase to $750. I didn't write the violation here, but it's a rule that says, as you know, the funeral directors and establishments must honor all financial debts owed to their retailers, wholesalers, whatever the technical term is.
Motion to accept.
Second.
A motion by Mr. Helms, a second by Mr. Cochran. All in favor say aye.
Aye.
Any opposed? Motion carries.
Next case, 2015-022-6191. Respondent's establishment license expired on August 31st and was not renewed until October 12th. Respondent handled 15 cases during this time. Respondent apologizes for the oversight and states that it was due to a miscommunication with his accountant. My recommendation is a consent order with a civil penalty of $750 and authorization for a hearing.
Approve the recommendation.
Motion by Mr. Rom, second by Mr. Bridges. All in favor say aye.
Aye.
Any opposed? Motion carries.
Case is case number 2015-022-7321. This was during a board inspection. Crematory inspection report was not available. There was a billboard with advertising violations and some funeral rule violations, which were 2 caskets, had price list inconsistencies, and there was no reason for embalming listed on 3 contracts. Respondent states that he's corrected the violations and stressed the importance of the embalming disclosure to his staff. So my recommendation would be a consent order with civil penalty of $250 and authorization for a hearing.
Motion to accept.
Second.
Motion by Mr. Cochran, a second by Mr. Rom. All in favor say aye.
Aye.
Any opposed? Motion carries.
Next case is case number 2015-022-5891 against an establishment, 2015-022-5892 against an apprentice funeral director, 2015-022-5893 against an apprentice embalmer. Complainant states that respondent apprentice performed a graveside committal service on December 6th without a supervisor or sponsor present. Additionally, he is advertising in a magazine as a funeral director, mortician, and pre-need counselor. Respondent Funeral Home states that they believed he was allowed to perform a committal service as long as a funeral director was in the area or nearby. Respondent apologizes for the advertisement and states that it should have used the name of a licensed funeral director. So my recommendation would be for the establishment a consent order with $1,000 in authorization for a hearing and a letter of warning for the apprentice.
Second.
Motion by Mr. Duffer, second by Mr. Rom. All in favor say aye.
Aye.
Any opposed? Motion carries.
I have one case to represent, and represents are cases that I've presented to the board before, but if a respondent or a complainant presents new information that I did not have at the time of the recommendation that I think is relevant, I'll bring it back for reconsideration. So this case, the original consent order was for overcharging a family, and then the next of kin did not sign the cremation authorization form before the cremation. Respondent then had the next of kin sign and backdated the cremation authorization form. But the additional information was that respondent did not overcharge the family as much as initially thought. It still resulted in an overcharge, but it was about $700 less than we originally thought. So the respondent did show proof that they refunded the family the excess charges. So the original civil penalty was for $2,000, and based on this new information, I recommend reducing the civil penalty to $1,500.
Make a motion to accept.
Second.
A motion by Mr. Cochran, second by Mr. Hams. All in favor say aye.
Aye.
Any opposed? Motion carry.
My legal report.
Thank you, Ms. Richards. On to the director's report, Mr. Robert Gribble.
Thank you, Mr. President. The first item that I have in my report is a budget report. Each month I meet with the accounting manager, who is Bill Holston, and Mr. Holston and Mr. Brian McCormick, who is Assistant Commissioner, will be before you later today to do a financial presentation. But if you look at this one page, what I call this one pager, I think that will help everyone understand better the details that they will go into when they come. And of course, for the three board members that have been here previously, you saw this at, I think, the October meeting. But I thought it'd be good for us to quickly go over it for all the board this morning, since the Assistant Commissioner and the Accounting Manager were coming to appear before the board. Every board has to be self-supporting, so that means that we have to collect enough money to pay our expenses. And with the funeral board, we have a high renewal rate on June the 30th of the even-numbered years. The state's fiscal year goes from July 1 through June the 30th. So we have 1 year where we have, for lack of a better word, a large profit, and the second year where we have a deficiency, because all the older funeral directors, embalmers, and older establishments all renew on June the 30th of the even-numbered years. So the way the legislature looks at that, as long as we're self-supporting over the 2-year period. But if we have 2 times that we have deficiencies, 2 consecutive times, then that automatically triggers a sunset. So we always want to make sure that we have more money than we have expenses. We have more income than we do expenses. So this is information that was based on financial data that was given to us by the Assistant Commissioner's Office on October 6, 2015. The balance beginning June 1, 2014 for the Board of Funeral Directors and Embalmers was $1,066,326. The revenue for July 1, 2014 through June 30, 2015 was $484,416, which made total funds available of $1,550,742. The expenditures for July 1, 2014 through June 30, 2015 was $387,109. And then we have costbacks, and costbacks are cost allocations charged to the board from administration, the investigation section, and also included in the administration costbacks are the legal costbacks. So the costbacks for this period was $180,468, which made our total expenditures, including costbacks, $567,577. So that was a fiscal year when we were down and obviously had a deficiency for that particular year. But when you look at our reserve balance and take the expenditures and costbacks from that, then we still have a reserve balance as of July 1, 2015 of $983,166. And for the new board members, we also reduced renewal fees from $275 to $235. And it would be my hope that we can look at that again at a reserve balance, maybe in the next couple of years and see how we're doing, and hopefully reduce fees again. Because I know most of you that have been licensed for some period of time will remember when licensure fees back probably about 15 years ago went from $100 to $275. So it was a huge increase at that time. And they've not increased since then, but did decrease recently from $275 to $235. If you have any questions about that, I'll be glad to answer those. And when the assistant commissioner and the accounting manager come in a few minutes, they'll go into more detail. But this just kind of the highlights of it. Anyone have any questions? Second item that I have is the legislative update. We as the staff, Ms. Richardson and I both, and also the department, wants to make sure that the board members are very aware of any legislation that the legislature is considering that would have an effect upon the board, or also provide you with information that might be of bills of interest to funeral directors and establishments. Typically, boards do not take a position on bills, but you may individually want to know about these matters, so you could contact your state representative or state senator and voice an opinion either for or against. There's one bill that will have a direct effect on the board that's being considered, and that's Senate Bill 2534 and House Bill 2569. And when you see the little asterisks, that means that that's what they consider the main bill. Whichever one has it, whether it's the House bill or Senate bill, we will notate that on each one. This bill, and I'll ask Ms. Richardson it has to do with people who have served as an apprentice funeral director and are attempting to get a funeral director's license. And it's an administration bill, which means it's in the governor's packet. Ms. Richardson, do you care to explain exactly what that does and how it affects this board?
What it really is just some cleanup. It won't change current operations. It's just making sure the statute is clear as to what we do now is in the statute. So nothing is actually changing, and we're just cleaning up the language a little bit. But it has to do with for funeral directors, you can do 2 years of apprenticeship, or if you go on to get your associate's degree, you only have to do 1 year. So nothing is actually changing based on how the board operates. It's just cleaning up that language.
All this is under the director's report. Everything that I'm talking about is under the director's report. And after you get through the first 3 pages, then page 4 of that is actually this House Bill 2569. And if you go to section 9, it says Tennessee Code Annotated Section 62-5-305B7 is amended and deleting the subdivision in its entirety and substituting instead the following language. Has completed 2 years of apprenticeship in the presence of and under the direction and supervision of a licensed funeral director. An associate's degree from a college accredited by the American Board of Funeral Service Education may be substituted for 1 year of apprenticeship. And that just makes it clear that if you graduated from a mortuary college, then you only have to do 1 year of apprenticeship. It doesn't increase, it doesn't decrease the educational requirements that we currently have. It's still the same. It just makes it abundantly clear in statute as to what. Those other bills listed are ones that may be of interest to you. And what I'll do after today's board meeting, I'll send you an email with this legislative attachment, so you'll have that, because that way you don't have to write all these bill numbers down or be concerned about them. And let me give you this disclosure. We attempt to include everything that we think that might be of interest to you, but there's, on the 3rd page, there's a legislative link for a legislative bill search. So if you want to just, when you get back to your home or funeral home, if you want to go to that link and just type in funeral, or cemetery or pre-need or trust, whatever you might want to be searching for, then if you type that in. And I will let you know that in the statute, pre-need is hyphenated everywhere. So if you type in pre-need, put the hyphen, P-R-E hyphen N-E-D. That's the way it's written throughout the statute. And I know that we typically don't do that within the industry. But if you're searching for a pre-need bill on that site, you'd want to do that. Questions about the legislative report? Licensee report. These are report of licenses that were administratively approved by the executive director pursuant to the board authority prior to the period, not prior, but for the period of December 8, 2015 through February 8, 2016. You have listed there 3 establishments and the types of actions for those, and then the individuals. And for the new board members, what the board has previously allowed us to do, if it's what's considered a routine application, we review that and administratively approve it. If there's any doubt as to whether or not any question about it or anything like that, then we bring it to the board and you make the decision about that. If I have a question or anything when I'm administratively reviewing, then we go to Ms. Richardson and ask her. And, but if she or I either one think it needs to be brought before the board, then we always bring those to the board. But this just lets the people get licensed earlier and with less expense, because years ago each person in each establishment was required to appear before the board, and the individuals that were appearing for licensure also usually brought a sponsor, and that became very burdensome to the people and to the funeral homes, and the expense in taking away usually 2 people for a day. Closed establishment report. There are 2 establishments that reported closing since the last board meeting: Cosmopolitan Funeral Services, 101 Hornbrook Street in Dyersburg, and Strother and White Funeral Home, 425 Walnut Grove Road in Hartsville, Tennessee. Disciplinary action report is a report of the consent orders administratively accepted or approved by the executive director pursuant to the board authority for the period of December 1, 2015 through January 31, 2016. And that lists the different establishments or individuals, what their violations were, and the action involved in the matter. Of course, all those have been approved by the board. Authorized. Well, they've all been authorized by the board, and then when they sign the consent order and send their payment in or whatever documents they're required to, then I sign on behalf of the board. That way, that lets the complaint be closed. And at the very end of that, on page 2, where it says the following individuals have had their license suspended in accordance, and gives 2 statutes there. Those 2 statutes are for failure to pay child support or failure to pay student loans. So if we have a licensee and they don't pay their child support or they don't pay their student loans, then those particular divisions contact the department, and by statute we're required to suspend their license. We do not have a choice. It's not appeal to anyone. If they don't pay those things, then when we get rid of written notification, we're required to go and suspend their license. So that means it could be either, we don't get as specific as to whether it's child support or student loans in the report, the public report we do, but it's one of the 2. And then when they make arrangements with those agencies, then those agencies will send us a letter and tell us to reinstate them, and we do that at no charge to them. So the licensees aren't paying a fee to get it done, but if they practice while their license is suspended, then that's unlicensed activity. Last thing that I have is a complaint report to make you aware of the number of complaints. These are broken down by the profession. In the apprentices, there is 1 complaint. Funeral director and embalmers, there are 5 complaints. Establishments, there are 26 complaints. So we have a grand total of 32 complaints. Now they could be different. They could be multiple license associated with those complaints, so there could be complaints against more licensees than that. Like when Ms. Richardson presents a case to you and you see, or she presents a complaint and you see two case numbers, like where there's a manager in an establishment. So that means that there were 26 complaints opened under an establishment. There could be some manager, licensed, or funeral director, or some unlicensed people affected in those complaints. But that's the number that we have to. I'll be glad to answer any questions you have if you have those. Otherwise, Mr. President, that completes my report.
Thank you, Mr. Gribble. I ask for an approval for the director's report.
Make a motion to approve.
Second.
Motion by Mr. Helms, a second by Mr. Rahm. All in favor say aye.
Aye.
Any opposed? Motion carries. Board financial presentation.
They're supposed to be here at 11 o'clock. That's
Okay.
when they're supposed to be here for that. If we could go on and
To the approval of license applications.
there are no individuals to appear before you today. There's one establishment, Essentials Funeral and Cremation Services. Mr. Brian Keith Givens would be the manager at 2114 Chapman Road, Suite 110, Chattanooga. It's a new establishment. It's owned by a corporation. The corporation is Precious Memories Enterprises Incorporated, located there in Chattanooga. And Mr. Givens is present today. If you will, Mr. Givens, come up and have a seat. For the benefit of the new members, this application was on the December agenda, and at that time I told Mr. Givens, as always, anyone's welcome to come to the meetings because they're open meetings and public meetings, but I'd indicated to him at that time it wasn't necessary for him to come. But when we presented the application, the board members indicated that they would like to have Mr. Givens present to answer whatever questions they might have, and also requested some documents. So he and I talked on the phone on December the 9th, and then I followed up with him on January the 8th, a letter letting him know for sure what the board members had decided. And he responded to us on February the 1st and provided an amended application, and also he provided a copy of the license and latest inspection report from the Georgia Board of Funeral Service regarding Dalton Funeral Home, which is located in Dalton, Georgia. This is the firm that's agreed to provide embalming, other preparation remains for this proposed establishment in Chattanooga. We do not have a certificate of occupancy. Mr. Givens talked to me prior to the meeting today and explained that to me, and I'm sure he'll be glad to explain that to the board. And he gave us some pages from websites that would indicate that the establishment churches or other organizations that he could use their facilities for viewing their funeral ceremonies, but he didn't provide any letters or agreements. So Mr. Givens, if you want to, just kind of make an opening statement to the board about what you're doing, what you want to do there in Chattanooga, and then the board members may have questions about other matters.
Brian Givens, licensed funeral director and embalmer, and I intend to operate a funeral establishment in Chattanooga, Tennessee.
Givens, are you currently employed with any funeral home in Tennessee?
No, sir.
Do any embalming at Turner Funeral Home in Chattanooga?
Yes, sir.
Givens, is it my understanding that you will not be doing any preparation of the bodies at this location? It will all be done off-site and brought to you? Is that correct, or am I
That's
misunderstanding?
correct.
All right.
That's gonna be done in Dalton, Georgia. Is that correct? That's correct. What, 30 miles difference, more or less, from Chattanooga to Dalton?
25 to 30 miles.
Okay. Is that gonna trigger some transit permits going state to state with each deceased?
Yes, sir.
Are you prepared to handle that?
Yes, sir.
Will the remains be casketed in Georgia and brought
Yes,
to
sir.
Tennessee? Casketed? I completely understand the venue that you'll be using for services not only include local churches and so forth, but also this venue that we have information on called The Venue.
Family so wishes to choose that venue, then that would be a family's decision.
Contracting through those third parties for that other venue?
I would contract just like you do your establishment. Concerning churches and venues and that type of thing.
What all will you offer at your establishment, your physical building? What will you offer there? I mean, is it just a place to come in and make arrangements? Is that all it?
And meet with families, yes, sir.
Digital selection room or online selection room, or will you have physical caskets?
Have casket books.
Have any idea how many families you'll be able to serve out of this location?
Question.
How many families do you plan to serve out of this location?
As many as I can.
Are you the only funeral director?
Yes, sir.
Years have you been in funeral service, Mr. Gibbon?
Graduated from John Gupton College. I'd say it's a very good school. That I turned in over 120-something embalming reports my first semester, and done the majority of those at Woodlawn Funeral Home, and opportunity they let me come down there and practice. So thank you, Mr. Duffer. Good place to practice.
Crematory you're going to use will be in Monteagle, Tennessee?
Yes, sir.
On the letter of occupancy from the city of Chattanooga, is there a reasoning that you couldn't get that?
The Hamilton County zoning people told me that a certificate of occupancy is only issued after a building permit, gas permit, or any type of repair permit has been pulled for them to go in and inspect, make sure everything's right, and when it is, then they give you a certificate of occupancy to go back into the place. In my case, I never had to pull a building permit or any other type of permit. Therefore, they would not give me one and said I didn't need one.
Dealt with that before? Has that been an issue?
Rules do not specifically require a certificate of occupancy, but that is something that a document that's been presented to the board before in prior occasions to show proof that it's approved by the city. Of course, when Mr. Hinkle served on the board as a consumer member, he was very familiar with that, and for his for his livelihood. So it's not specified as in the rule as a requirement for licensure. I think that discretion's left to the board.
Yeah, the discretion is left to the board.
And so basically, they said that you didn't have to have the certificate of occupancy because the building, it was already an existing structure, basically?
Right, and I did not pull any building permits, repair permits, gas permits, those type of things.
Okay.
That was issued after you pull one, they go in and inspect to make sure that whatever was done correctly, and then they say you can occupy the building. That's what that is.
Building used for before you got it.
Funeral establishment.
I see a large bay window, garage door.
Funeral establishment was at that location and relocated.
I'll speak. I have some concerns. One is logistics involved in being in Chattanooga, embalming in Dalton, Georgia, cremating in Mont Eagle. That to me, that throws up some red flags.
It's
Certificate of occupancy, that's another red flag for me. We've always had that in hand.
there are other funeral homes that use that same crematory in Chattanooga. It's not a problem for them, and I'm sure it's not going to be a problem for me. Dalton, Georgia is 25 miles. I'm physically able to take care of that. I know there's other travel much farther than that, so I don't see it being a burden upon myself.
Just the two different states in operation, to me, that would be the headache there with the transit permits and back and forth.
Your recommendation, you would want me to do that in Tennessee?
Not my call. I just see some issues. I'm not saying it can't be done, but I just see some issues.
Elaborate on that.
Typically, a full establishment facility, we don't even have those issues. We're not contracting out to another facility, especially across the state line.
And not all funeral homes embalm at their facilities.
Not all do. I know that.
So, I mean, let me rephrase my question. You have a red flag with the embalming in Georgia.
Not necessarily, not per se. I just say it could be an issue.
Could be or is. That's what I'm asking. You know, to help me prepare and make any corrections, and that's what I'm asking.
It's an unusual request on the application to involve Tennessee versus Georgia. And everything's being done off-site. And that's my concern. I'm just bringing it up for the other board members.
Mr. Gribble, can you remember a time in the past where establishments have embalmed in another state and transported back to Tennessee? And that's what's occurring here. You would embalm in Georgia and then transport it back to Tennessee for the service.
Cochran, I can say this. I don't remember it. That doesn't mean it's not ever been done in the past. I don't recall it. Do you recall the situation?
I don't recall.
Okay.
Typically, the letters that we get, like Mr. Helm said, you know, there's plenty of establishments that do not do embalming in their own facility. But we get a letter from a Tennessee licensed establishment that says if this application is approved by the board, then we'll provide embalming, casketing, cosmetizing, and all services related to embalming for this particular establishment. In the time that I've been here, my only memory is that comes from a Tennessee licensed establishment. But of the board.
Mr. Richardson, do you know of any issues? And you may just not have knowledge about this, but do you know of any issues of transporting a body across the state line?
The only time I hear of it is during a complaint, like if something happened and the two funeral homes don't agree. I have not seen it in this situation, so it might not be happening, it might be happening and not be an issue. I'm just not aware.
I'm assuming most of the deaths will occur in the Chattanooga area in Tennessee, and they'll be carried from Tennessee to Georgia and from Georgia back to Tennessee. Is that the scenario you?
State line there, there's hospices in Georgia right there. Deaths will be occurring.
A while ago, you did some embalming for Turner. You used to have a good working relationship with Turner Funeral Home there in Chattanooga. They allow you to do embalming at their facility?
Do they allow me to do?
Will they allow you to do embalming at their facility?
Should they or shouldn't they?
Will they?
Well, I'm asking you, should they or shouldn't they?
I think you might be suggesting that it might be a better solution if you could get the bodies embalmed in Chattanooga rather than carried across the state line. Would that be a possibility?
Well, I think we can just go ahead and take care of that. Got a letter here from Tennessee Funeral Home that will allow me to take care of that.
The best, I think the best thing for everyone. Eliminate any kind of problem.
Well, there's Tennessee Funeral Homes that cremate in Georgia, and we're all in this business. We all know what this is about. So, I think that I'm within the statutes and regulations to operate the establishment.
President, this letter is from Bywards Funeral Home, Decatur Chapel in Decatur, Tennessee, and it's addressed to the board. It says, to whom it may concern, Bywards Funeral Home is offering their services to Essentials Funeral and Cremation Services, Manager Brian Gibbons, to assist his establishment as he may need. Please feel free to give us a call should you have any questions. Bywards owner. All three of these letters are the same, aren't they, Mr. Gibbons?
I think that's, yeah, I believe so.
Back to you and hold on to one for the record then.
Mr. Gribble, that says that
They
it
wanna see
offers it offers their services. It doesn't say it offers their facilities, but their services.
It says to assist his establishment as he may need. Yeah. It says Bowers Funeral Home is offering their services to Essentials Funeral and Cremation Services Manager Brian Givens to assist his establishment as he may need. We can pass this around, and each one of you can look at it if you want to.
Are you reading that as it will allow him to do preparation at their facilities, or they will do the preparation for him at their facilities?
Unclear as to which would be the right answer to the correct answer to that, Mr. Ron.
Is that how you understand it, Mr. Givens? That basically, if you need to embalm a body at Bowers Funeral Home, they'll let you embalm a body there.
What's the correct answer?
Well, I just is that how you understand it? That Bowers is saying if you need our facility to embalm a body, you are allowed to use that. Is that how you understood your agreement with them?
Well, the statute says that I have to have a place that will do my embalming. Is that the way the statute reads?
I don't have it in front of me. But like I said, just in your understanding and your agreement with Bowers was basically Bowers Funeral Home offering their facilities for embalming if you need it. Is that how you understand it?
Exactly what that says.
Okay.
And any other services as well.
Okay.
Mr. Givens,
Yes, sir.
this letter that you presented to the board, it's not dated. Can you just tell me, I'm just curious, when he signed this?
Approximately 1 week ago.
Thank you.
The statute in reference is 62-5-314B2, which says each funeral establishment must have available for its use a preparation room equipped, and then it goes on.
Okay. Thank you.
Mr. Givens, as the licensed funeral director and manager of your facility, will you have any other licensed staff?
Yes, sir.
How many other licensed staff will you have?
I will begin the hiring process, taking applications and hiring by federal and state laws, as far as the interview process.
Seeking dual license individuals or single license?
I would give equal weight to that. I'm an equal opportunity employer.
You look to, at some point in time down the road, if this board approves this location, do you look to move from this storefront type of location to a permanent facility with chapel availability, or do you see yourself staying in a storefront?
Getting a permanent facility.
In your mind, how many calls would you have to do before you consider a permanent location? Off the top of your head, how many calls do you think you'll be doing when you How many calls do you anticipate being able to do the first year?
Board, how will we know that if we grant your establishment license, how do we know that you're going to be given this certificate of occupancy from Chattanooga?
Let me reiterate what I said earlier about that. Hamilton County and Chattanooga will not issue a certificate of occupancy until any repairs and building permits have been pulled. And then inspections are done to make sure that any repairs or alterations and things like that are done. I have not had to pull any building permits, repair permits, or any other permits. They will not issue me a certificate of occupancy because I have not pulled any permits for those repairs. Then they don't require that.
So we are to understand we won't ever get a CO. Or you won't ever get a CO because they just don't issue them for that circumstance. Is that correct?
They'll issue me one if I ever have to pull a building permit or
Right,
something.
but under
like
your current circumstances, you will not ever receive a certificate of occupancy. Is that correct? Mr. Helms, I'm in agreement with you on the CO. I just have some concerns as far as the practicality of this particular location. How does this board know that it is suitable for this type of facility, even though it may be a storefront? Is it improper, as a new member of this board, is it improper to request something from the city of Chattanooga in some form of documentation saying that this meets their codes or something of that nature?
Would be nice to get some type of opinion stating that.
Would I don't know, would page 30 cover that in our packet? Which is basically just telling what type of zone that building is approved for?
This building was a prior funeral establishment.
Okay.
And had no problems with their certificate of occupancy or any other zoning issues.
Board, we have to look at each establishment request individually. We got to go through the same process every time, so.
Saying that the city of Chattanooga is well aware of all that and what I need and what I don't need, and I've done discussed it. As a matter of fact, they had said they don't issue letters stating they do or don't and all that. You're welcome to check their web. Say what I'm told.
Of course, this letter just defines the zoning. It doesn't outline really anything else.
So I guess my only question might be, maybe, is there anything that the board needs to do, and maybe this is to Mr. Gribble or to Ms. Richardson, is there anything that we need to check out further as far as the transporting of a body across state lines? I guess that's the only place where I might still be a little bit gray. I mean, is there any due diligence that we need to do?
And we just took care of the transporting across state
We
lines.
use Bowers Funeral Home now.
Okay,
That's it.
so now so basically you're only going to use Bowers. You're not going to transport across state lines.
Right, that's the letter I submitted.
Okay, gotcha. I didn't know if
Right.
if you were still going to possibly use the one in Georgia. So you're not okay.
I got that Tennessee letter for.
Okay.
If the death occurs in Georgia, are you going to transport it to Tennessee for a prep, or are you gonna do it in Georgia?
If the crew's in Georgia, I'd be like Chattanooga Funeral Home. I'd go get it. Like they would. Or any other establishment.
Go ahead, I'm sorry. No.
So you will not be using the facility in Georgia at all for preparation, it'll all be done in Tennessee, no matter where the death occurs?
If a Florida funeral home calls me and then,
Well, Florida's
or
not,
I've got a
Florida's
family
not in
down
the,
there,
Florida's not in the equation.
Florida
We're
and
looking at
Georgia.
Georgia and Tennessee. If the death occurred in Georgia, are you gonna have it embalmed in Georgia, or are you gonna do it in Tennessee?
Tennessee.
This brings up a whole nother, you were indicating that the bodies would be casketed and so forth at the location in Georgia. Is Bowers Funeral Home gonna allow you the same availability to casket your remains? And what needs to be done to get them to wherever they're going?
Yes, sir.
Okay.
I'm familiar with East Tennessee. How far is Decatur, Tennessee from Chattanooga?
5 miles, something like that.
Same as going to Dalton.
Yeah.
It's
I'm just,
going a little more north.
just trying to get a picture.
Yeah. Chattanooga, but you know, we're gonna be competing, and I don't think that'd be a
Robert, do you see any issues preventing the approval of this establishment license?
It's completely left to the discretion of the board. Ms. Richards?
But no specific.
None other than had already been discussed. Like there are no like blanket prohibitions that
Okay.
he has not met.
There's no specific line in the statute that he hasn't fulfilled.
I would say personally, I kind of struggle with these applications, just from my point of view. I'm an old school funeral director. However, if Mr. Givens is meeting all the requirements in this book, as a board, you know, I think he's met the requirements. My opinion.
I feel better now that all the establishments he's gonna be working with are in Tennessee.
Right. Yeah, that's a game changer.
Well, based on, again, as you just mentioned, based on the fact that we don't see anything in statute that he has not met, I'll make a recommendation to accept.
I'll second.
A motion by Mr. Cochran, a second by Mr. Helms.
One more question, Mr.
Okay.
President. Is there a way that this board can secure a type of document indicating that he is using Bowers Funeral Home for his, even though we have the letter, that doesn't mean we know that's what he's doing? Way to,
Mr. Gribble can correct me if I'm wrong, but each yearly inspection, the inspector checks that there is a preparation room available for use. So we're supposed to have these letters, you know, if it changes, the funeral establishment is required to update us on like which other establishment they're using.
Motion by Mr. Cochran, a second by Mr. Helms. All in favor say aye. Any opposed?
hey,
Roll call.
Dennis Bridges. Mark Cawthorn.
Yes.
Robert Davis. Jeff Duffer.
Yes.
Robert Helms.
Yes.
David Neal.
Yes.
Charles Ram.
no.
Mr. President, we have 6 yes and 1 no.
Thank you, Ms. Mosby. Motion passes. Congratulations, Mr. Givens.
Even if you will, supply us with some current phone numbers and contact information if that's okay.
I'll get the business phone turned on probably sometime today when I get.
If you just call the office and talk to Miss Mosby or to me and give us that contact information, then we'll get you a license issued then.
You want me to go on up there?
No, it's not necessary for you to go. If you want,
Oh, you said to call back to your
yeah, if you want to
office.
call back, you don't
Oh,
have to.
okay.
You don't have to go
Yeah.
upstairs. If you want to just call us back later today or tomorrow when you have your phone numbers, yeah, that contact information. Just speak with Miss Mosby or me, either one, and we'll be glad to take it over the phone. Or you can send me an email if you want to. Either one, whichever is best. We'll get your license issued then.
Again, thank you for your consideration and time.
Thank you, Mr. Gill.
Thank you.
Board financial presentation, Mr. Gribble, is that ready?
It's Assistant Commissioner Brian McCormack and Bill Holston, who's a CPA and accounting manager. As I mentioned to the board members, I meet with Mr. Holston each month, and we go over financials for the board. And of course, Mr. McCormack's who I report to. He's my boss. He's my supervisor.
Good morning.
Thank you, President, members, and it's fun to see a bunch of new faces here. I know we've had a pretty significant turnover, and it was just getting to watch the conversation a minute ago, and I noticed we have new members who are jumping right in. So I think that's a great thing for your board moving forward. And this is kind of just kind of give you an overview why we do this. We've Deputy Commissioner Jeannie, when he was Assistant Commissioner, made this a priority to come after part of each new calendar year to talk about the previous year's fiscal close as you all are thinking about kind of where you are financially, and this is really more broad, big picture conversation about the direction we're headed, and then an opportunity questions that you have regarding really this or any other subject. So I just like to be available at least. So for the new members, I think this is all on the iPad. Is that correct, Robert? Okay, so if you all have had a chance to look at it, what we do is we break out the previous fiscal year, and it's a 4-year overview is what we put in the document, so you can kind of see a trend in terms of how you're doing over that time frame. And one of the things for some of the new members to know, we kind of in some programs we have what we call an up-down year for revenue. So most of your revenue comes in through a renewal, kind of odd year. Yes. So it's, yeah. And so if you can see, you'll notice there's kind of a dip in revenue one year, and the next year there's a lot higher revenue, and that's why that's the case. And so I'll kind of go broadly, but hammer down if you have any questions. The first major thing I focus on is payroll, and you can see your payrolls a little bit down from the previous year, but pretty consistent over the last 4 years in terms of what you have. It's a breakdown of all these very specific expenses, and you can see the total other expenditures is $111,000, and that's pretty consistent, basically staying flat from where you were in the previous year. So your expenses there are $387,000, and that's actually a decrease from the previous fiscal year, but continuing to stay pretty much in the same range you all have over the prior 4 years. The next line item for particularly for those who are new, we call this cost backs. This is how we split out your share of administrative overhead, legal investigations. It's all the things that you pay for that kind of help that you split with other programs. And so we have a process of how we do that we divvy out costs at the end of the year. And so just to look at your cost back this year, it was up just a little bit from the previous year, and that's really because of a little bit of an increase in cost related to you all for legal expenses, and the same for administration. But it's basically staying in the same general area you have been, so it's not particularly concerning to me, that adjustment. Looking at your you did have a little bit more specific investigation costs, so that was one additional line item I'd want to point out. But your total expenditures for this year were
$567,577, and that's still kind of staying flat from where we've been in the previous years. Looking at the licensing revenue line, this is what I was kind of talking about as an kind of these up down years, and over the last two cycles in 11-12 you were at right around $1 million, and then 13-14, which is comparable, you were at 916,000. And then FY 12-13, you were at 400,000, and you went up to about 446. So you're staying generally in the same. You had a little bit of a dip in the previous cycle, but you're back up in this cycle in terms of revenue. And so your additional revenue there for case and complaint. We have this state regulatory fee that I may have Bill describe, but there's a $5 fee that's attached to every license that you have to pay, and that goes to Bill. Can you kind of articulate that just
sure.
generally?
Absolutely. The state regulatory fee is actually big administration of the commerce and insurance cannot directly charge regulatory boards for cost backs. That $5 fee for each license is paid by each program and regulatory boards to FNA to reimburse for those administrative costs of TDCI. So I can get more, that's it in generally, but I can get more specific.
And kind of stay high level. That $5 fee has been the same for some time, so we often don't talk too much about it since it hasn't gone up much. But that takes you to, so that's reduced from your overall revenue, which takes you a net revenue of this year $484,416. And so your expenditures in this year are over your revenue, but that's not concerning because we really do look at this from a 2-year cycle standpoint. So as you can see, you draw on your actual reserves. So last year's prior fiscal year reserve was little over $1 million, and so this year your reserves will drop down to $980,000. But you're very, very comfortably in a good position. We ask for programs to have about 2 years of operating expenses in terms of reserves, and you all are tracking right along with that. So you have a very healthy reserve, and really nothing particularly concerning for us regarding kind of where you are. I think this is a very, very well positioned the board's well positioned financially. And one other just expense I'll point out here, you can see in terms of reserves, there's very little you can spend your reserve money on other than taking it to pay if you've gone in the red for a particular year, and that's one of the only things you can do it for. There are a couple of limited exceptions. One of the things we did was pay for we have a new licensing system that has been implemented across the division. So every program that we have is using this system, and we upgraded. Our system had been around since before the upgrade had happened in the early 90s. It was a DOS-based system, if that means anything. You can kind of tell you how far back that was. And so we were able to spread the cost through all the programs, and it was the system was a multi-million-dollar system, but for you all, your expense of that was very, very small because we were able to spread it across. But that was paid for from the reserves. You won't see very many expenditures outside of the reserves other than to pay for the discrepancy revenue expenditures in your down year. So I've talked a lot. I wanted to open the floor for any questions or any conversation.
questions, but I appreciate you coming and presenting it for us, giving us a 4-year look back.
Great. Well, I'm really grateful to be here. I think I just want to say, if I have an opportunity, that Director Gribble does a really, really great job managing the organization. I think it's a credit to him and to you all that this board is running so smoothly in terms of operations. But I any chance I can to brag on Robert, I'm glad to do so. So
Afterwards.
yeah. So it's a great thing. We're real excited, and I just, for the new members, I said this to you all earlier, but we're really grateful for your service to the state, to the public, and to the industry to which you're regulating. Honor. I know that you all know that, but we're grateful to have you here and look forward to working with each and every one of you as we move forward.
Thank you, Mr. McCormack,
Very
Mr.
much.
Huddleston. Thank you. Business.
Yes, I have some new business. Zach, do you want to pass it out? I don't know if any of y'all have been paying attention to the regulatory world and the big picture, but the Supreme Court issued a fairly interesting case this past term called North Carolina Board of Dental Examiners versus the Federal Trade Commission. And I just want to give you a brief overview of that case because it sort of changed how the whole country understood the authority of regulatory boards. So I just wanted to give you a brief overview in that. And the basics, it starts off with the Antitrust Act, the Sherman Act, which, and boiled down as strong as possible, is just any restraint on trade is an antitrust action and illegal. But the states, as the states are, they're endowed with authority to regulate the public health, safety, and welfare. So because of that power, they have an exception. So restraint of trade that the state does through statute or whatever is exempt, and it's not subject to antitrust regulation in the Federal Trade Commission. But North Carolina Board of Dental Examiners were a bad actor, and the Federal Trade Commission went after them, and it sort of changed a little bit of the landscape. What happened is a very unique situation, first of all. I'll just start off with that. So some people are panicking, thinking this is like changing everything. I personally don't think that, but I just want to give you all the facts. First of all, the North Carolina Dental Board, those members were not appointed by the governor. They were elected by dentists. So they were elected by the licensees. And what they decided to do is they decided to issue cease and desist letters to little whitening kiosks in malls and things like that, saying this is the practice of dentistry, it's cutting in, there were things on the record saying this is hurting dentists, it's cutting into their business, we want to protect dentists, so we're going to go after these whitening kiosks. And there was nothing in their statute that said that teeth whitening was actually part of the practice of dentistry. And they didn't do any complaint process, they didn't open an unlicensed activity case. They just sent these blanket cease and desist letters to these kiosks and to the landlords. So all of these kiosks shut down. The landlord said, this is illegal, you can't do it. They all shut down. And the FTC got wind of it and filed an antitrust case against them. And so the Supreme Court sided with the FTC and said that you went beyond the authority of the state and you are no longer under antitrust protection because you exceeded your authority. So that's really the big issue. We have this antitrust protection because we're under the authority of the state. But if this board or any board somehow goes way beyond and exceeds the authority, they will be subject to antitrust prosecution. And so the Supreme Court just got this test. There are two main points. Any restraint of trade that we can, as boards, can enforce must be clearly articulated by the state legislature. So that just means it must be clearly in our statute or a rule, like what you can and can't do. You can't just go, I don't even know what would be what would be analogous to teeth whitening in this industry. You can't just like go, this has never really been considered part of funeral directing, but we're going to say it is, and we're going to start regulating it like out of nowhere. You can't do that. And then you're exceeding your authority by the state.
Third-party casket sellers would probably be something that,
Right. That would be good. Like you can't just, oh, we're going to start regulating monument companies now. Like that's not in our statute. You can't do that. If we do, you could open yourself up to a lawsuit. And then the second part is any restraint of trade must be actively supervised by the state. And in the North Carolina Dental Board case, the Supreme Court said not only did you go outside of your statute, you weren't being actively supervised by the state. You said you were out to protect your industry. You didn't really care. It wasn't about the public. It was about protecting your industry. That's like in multiple places on the record. They're all elected by the industry to protect the industry instead of appointed. And there was no active supervision, in which case each states are a little different. Here, we're under the Commerce and Insurance. I'm employed by the state, so I can tell you whether you're exceeding your bounds or not. So there's a lot of discussion nationally as to what actively supervised means. Some states have completely panicked and said they have to abolish all regulatory boards. I don't read the case that way. I gave you copies. Feel free to read it yourself. Please read it yourself, and if you have any questions, call and ask me. They didn't give a lot of guidelines, so it's very much up in the air as to what is active supervision. I personally think we're fine. We're not doing anything clearly outside of our authority. The FTC has issued guidelines as to what they think is considered active supervision. You're welcome to look those up. I would just caution you that the FTC cannot tell you what the Supreme Court says, so they doesn't really have any sort of binding authority. It's just what they would want the case to mean. Whether or not the Supreme Court will agree with them is yet to be decided. So that's pretty much it. Read it. If you have any questions, just give me a call.
Thank you, Ms. Richardson. Is there any other new business to be brought before the board?
I just want to mention one thing, Mr. President. The 2010 edition of the funeral laws that Ms. Mosby gave to you, most everything is still current in this, but there are some significant changes, especially with who controls the right of disposition, and there's some other smaller things. So just always remember that the current laws are on the website, and the department's working with us to get an improved laws section on the website to where it would actually be searchable. I don't want to project when that'll be available, because I might say it'd be available in 3 weeks and it might be 6 weeks. But in the not too distant future, we hope to have an improved website, or hope to have an improved statutes on our website where it'd be easier to find. This is generally correct, but don't, if it's something you really want to know about, make sure you go to the website and double check it there.
Dribble. If there's no more new business, I'd ask for an adjournment.
Make a motion to adjourn.
Second.
Motion by Mr. Helms, second Mr. Cochran. This meeting is adjourned. Thank you.